The land and politics is not a mere emotive issue. It is an issue concerning global politics, national politics, sub-regional politics. Recently elected President Trump suddenly said even Canada will become 51st state of America. Canada is a separate country, it is a sovereign country. Not only he stopped with Canada, he also said Gaza Strip will be taken over by America. This kind of jingoism or imperial conquering of territories is one of the oldest slogans which we have seen during the first period of 20th century. But then the same slogans coming even in the national politics on an all India level. If you see the people who are tribals, under the Schedule 6 of the Constitution, we have given autonomy to certain areas. But the tribal people are still threatened for dispossession of their land, their water resources, their jungle. Jal, Zameen is their slogan initiated by them. Neelam, Vanam. This is something which is part of every tribal settlement. Their water resources are taken over for projects. Their lands are taken over for mining projects. The jungles are removed for development. And therefore, the tribal people also fight. They are not fighting for an individual ownership of a land, for a collective ownership of the material resources of this country. The Jal Jameen Zangal is a slogan which is being put through them, and the result is they are faced with arrest. Father Sami was fighting for the Jharkhand tribal people. The Jharkhandis have been arrested and he died in the jail itself. And this is something which we will have to understand while talking about the land distribution in a very just manner. Is although the collective ownership of our own land resources are under threat, and therefore it is in that context we will have to understand the land relationship between land and politics in this state also. And I must tell you, I saw the position paper. The land reforms which we are talking about, we got independence in 47, got the constitution in 1950, first elections in 1952, second election in 57. It is only after 1960, when Congress party thought they may lose people's support, that they have not fulfilled the promise which they made before the British left, they started bringing land reforms. It is only in the second 5-year plan they thought of agriculture and maximizing production and distribution and the scientific cultivation of land. In that sense, 1961 saw the first Tamil Nadu land reform ceiling law, where 30 standard acres were fixed for a ceiling a person can own. We know what happened to the ceiling. In fact, in Tamil they used to say, in Tamil the word equivalent word ceiling is Uchavarambu. But here it turned out to be a Michavarambu. That is what is left out by landlord, they gave the land for the others. The 1961 land ceiling law, the 1963 Inam Abolition Act, and 1968 the Record of Tenancy Act, these three acts, which gave some protection to the tenants, and the Inam abolition immediately led to the possession, lawful possession of the tenants. But you must understand our rural areas. Who are the tenants? The tenants are the OBCs, not the Dalits. The entire land were held by the OBCs, and by these three successive land reforms, the OBCs consolidated their land holding. We should understand when we talk about land, it is not the ownership, it is not the title. When we go to a rural area, we don't ask them how much land you own, how much land you control. The control over land in rural areas directly came to be vested with the OBCs, and Dalits continue to be agricultural laborers, or many times the farm serf, panne adiment, they serve in the various forms. And therefore, first thing that we must understand, the land reforms of the second 5-year plan, of the second tenure of the Congress party, led to the consolidation of land in the hands of the OBCs. and Dalits were continued to be kept outside the system of land cultivation. Number one. Number two, the 1961 Act also provided for the distribution of surplus land. Distribution of the surplus land has got the criteria for distribution, and one such category for which land can be given is a landless poor. They deliberately did not include Dalit as a specific category. They merely said landless poor. Only one case in Madras High Court in the 70s said that landless poor includes scheduled castes also. Thanks to the Madras High Court, we had some concession. But the given situation of the bureaucracy, the Tahsildar is the authorized officer to distribute, and when he produces a list of surplus land and the beneficiaries, invariably the beneficiaries are not the scheduled castes because they do not control the rural politics. They are kept outside the politics, and therefore, invariably, the surplus land mostly went to the OBCs and not to the Dalits. In fact, we must conduct a scientific study. How much of the surplus land went to the Dalits is one issue which we have to do. When the 1961 Act failed as a ceiling act, in 1971, the DMK government brought a second amendment reducing the ceiling to 15 standing acres. So between 61 to 1971, the 15 standing acres should have resulted in thousands of acres become surplus. But on the other hand, in the 10-year period, many internal divisions have taken place by bogus documents, bogus paperwork. Many landowners started giving the land to the daughters. That is how the women also got some paper possession of the land. The 1971 Act nullified all the land transactions that took place during from 61 to 71, and that was challenged, and the challenge continued for several years, and finally it came to be in 2008. I dismissed that writ petition and upholding fictitious transfer cannot defeat the land transfer, and therefore that 1971 Act was upheld. Not in 1971, but after 20 years, it has been upheld by this court. But nevertheless, during this fictitious transfer, we also found two important developments. One, women were never given land. Suddenly, the landowner fathers started giving land to the owner by a family arrangement. That is why it is not the ownership; it's a holding. Even if you give it to the daughter or two daughters or three daughters, it will be held by the same family only, either the elder brothers or the father. It will be continued to be held by them, but on paper it will be with the name of the daughter. In Tamil Nadu, more than Tamil Nadu, in Andhra Pradesh, many old people started getting divorced at the age of 80 to defeat the land ceiling. So the women got land by a divorce on paper, but then the old people continued to live. We also got a strange development in our country when it comes to land, and it is that one. There are two other enactments. I also saw the Urban Ceiling Act of 1978. Suddenly, many of the fathers started giving the urban land to the daughter also. Many of the land transactions took place, hoping that the land holding kept by them will not be diminished by the land ceiling, whether urban land ceiling or a local land ceiling. It is in that sense we should also understand how our society, they work overtime to defeat many of the land reforms. The reason is we do not have a movement at the rural level to rise and protest and try to get what is legitimately due to them. When 61 to 71 reduced the land ceiling from 30 acres to 15 acres, we did not get back the benefit of the entire ceiling law. Whereas in West Bengal, 6 million acres were declared surplus, and thanks to the agricultural laborers movement, the land went to the actual tillers in that land, and that movement is lacking in some of the southern states. And one reason why the land never comes, because the land politics is a consolidated politics of the OBCs, and they try to capture not only the land but also the political power and economic power, and therefore we continue to keep the Dalits outside. The second question is, during the British, when they gave the Panjami land, it was specifically recorded that the land cannot be transferred out from the beneficiary, and we continue to see lands going from the Dalits to non-Dalits. Even some of the places it become real estate. And even during the period of Jayalalitha, a commission was appointed whether the lands held by her in Payyanur near Mahabalipuram were the Panjami lands. So the Panjami land issue is mostly used like a political issue, not an issue of empowerment of Dalits. And when the SC/ST Act was framed in Tamil Nadu, I was also asked to give an opinion on the formation of the Act. So one of the power of the state SC/ST commission, I included that they will have the power to inquire into the ownership of the present ownership of the Panjabi land. Then the matter went to the committee of secretaries, and secretaries don't want the commission to have such power, so they removed the power from the commission, that they will not have this power to inquire into. And only question is, an inquiry reveals statistics. It cannot get back the land, but at least it puts the government in a planning process in a more progressive manner when the data is available. Today we talk about Panjami land, thousands of acres being transferred, but then we do not have movement to recover these land. Recently, one of the order passed by the SC/ST commission, they recovered some Panjami land. How long it will stand the legal scrutiny, we do not know. But nevertheless, we cannot be left only with Panjabi land. In fact, when Sivagami started a movement in their party, they were also asking for a specific land allotment for the scheduled caste, not just what the British gave. The new government should also committed to give the agricultural laborer the land ownership. This is one area that we have to see the benefits of land reforms, when to whom, and how that could be decentralized. In that context, I want to tell you one more issue. The 39B of the Constitution, in the directive principle, where the material resources of the community shall be taken over and distributed for a wider use of the public. Now, the material resources, does it mean only the state resource or the private resource? Justice Chandru and Justice Pudhiya have ruled that material resources mean both public and private ownership. And that went to a 9-judge bench headed by the previous Chief Justice Chandru. Even on the starting day of the case, he told the Solicitor General, we are not accepting the Marxist interpretation of Krishna here. Where does the Marxist interpretation? We do not know. The Constitution was prepared by Dr. Madras High Court. The material resources of the world means it's not only the public resources, it means everything in that sense. And Chandru also followed the same judgment. Now they overruled both the judgments by saying that these two judges have led this country to a disaster path. When public started protesting against that passage from the judgment, quietly the Chief Justice removed those two passages. But nevertheless, today, whatever the intention of the Constitutional Assembly, whatever the intention that Baba Sahib thought under 39B has been diluted in the name of privatization, liberalization. In this liberalized economy, the judges are not willing to interpret law in a socialist sense. The socialism is there in the preamble. And the socialist preamble was sought to be removed by Sami, which was rejected by the Supreme Court, saying that it is part of the Constitution. If you read the Constitution, you can never escape. The Constitution has a socialist chapter. When the majority of the people are poor, majority of the people are still egging out for a living, the state must move towards a socialist path. That is how the Constitution has been framed. But today we have judges who interpret the Constitution out and out in favor of Adanis and Ambanis. And in that sense, we should also fight for a larger question, not merely land question, the very question of economic planning, social planning, and in that sense, we should fight for a larger sense. And finally, I will end up by saying, when land and politics, it is not something which is only 1 century old, 2 century old. It has been there ever since the private ownership started. There is a brilliant essay by Frederick Engels, Origin of Private Property, the Family, Primary Property and State. And I think you should read that, understand how the land became the ownership of the private people. And even in that private ownership, how the women were excluded from the private ownership. Like one of the topics in our position paper is also how women, mostly the Dalit women, have been excluded from the. I will not go into details of that. If you see the our consistent legal reforms in the area of women ownership. We find women are always kept outside the system of property, and most particularly the land. And that is another issue, not merely the Dalit women. Women as a whole have been kept outside the property. And one of the reasons given by Engels is that the day when the man took over the means of production, the cattle, the livestock, the land, and the women have been kept only for the home family work. And thanks to Justice Prabhasi, who found there is also value for a home work. They are not mere these salary-less workers. The homemaker is also produces wealth, and some of the judgments are landmark judgments. In the same way, when we upheld Panjami land in 2008, I was the first to write a judgment that the Panjami land transfer are all invalid. It has become void, it has to come back to the Dalits. And she, sitting in a division bench, has confirmed the order in 2010. Therefore, there is something, a small legal advancement on the right of the people. But the rights has to be realized in the actual terms. And for that, we need not just the seminar. Beyond that, we need a people's movement. I am sure Sivagami will lead such a movement in future. Thank you.